Call the Board of Adjustments and Appeals meeting to order. Ms. Work, please take the roll.
Mr. Cole,
Here.
Miss Ozels,
Here.
Mr. Friesen,
Present.
Mr. Koenig,
Here.
Miss Dickerson,
Here.
Chair Taylor.
Present. All right. We have a bit of business to get through before we can get to our public hearing tonight. We have a couple minutes to approve and findings of fact. And then we also have, after the public hearing, our study session on the STR waivers presentation that we missed last month. So do I need a motion and a second for the draft minutes for September 10th, 2025?
Move to approve meeting minutes as written.
Second.
Anyone need to abstain because?
Sorry, who was second?
All right. What was it? What was the question? Okay.
Actually, Chair, under Bob's Rules of Order, there's a specific provision on abstentions, and having not been at a prior meeting is not a basis for
Okay.
abstaining for on a vote for meeting minutes.
That's good to know. All right. So all those in favor of approving the minutes for September 10th, 2025, please say aye.
Aye.
Aye. Any opposed? Any abstentions? All right. We need approval of the draft minutes for October 8th, 2025. Do I have a motion and a second?
Move to approve the minutes for October 8th.
Second.
All right, let's do a voice vote again. All in favor, please say aye.
Aye.
Aye. Any opposed? Any abstentions? See one abstention.
Shouldn't there be two? Because I think nobody was here.
Oh, we were here.
Well, no, but I thought that
Just because you're not here doesn't mean you can vote. You can abstain from that vote. All right. We have approval of the findings of fact in case VAR 2025-004 at 4983 South Fox Street. I need a motion and a second.
Move to approve the finding of facts for the aforementioned address.
Second.
We can do a voice vote again. All in favor, please say aye.
Aye.
Aye. Any opposed? All right. Yes. All right.
abstention.
Oh, abstentions? All right. All right, next moving on to a public forum. This is an opportunity for the public to address the board regarding items not on the agenda. So items that have a public hearing scheduled on this agenda are not appropriate for this public forum. Commissioners, our board members and staff will not engage in a dialogue or answer questions during this time. Speakers may be directed to staff or other sources for responses at a later date to questions raised during this public forum. Presentations are limited to 3 minutes. Questions and comments may be mailed to comdev@inglewoodco.gov. Do we have anyone online?
No.
Do we have anyone in person? No. All right. So we can move on to the public hearing for tonight in case VAR 2025-010 for the property at 4450 South Fox Street. Sorry, I need to go through my procedure script here. There are 7 of us here tonight. Or 6 of us here tonight, so 5 votes are required. Affirmative votes are required to grant a variance or appeal. The board is authorized to grant or deny a variance by Part 3, Section 60 of the Englewood City Charter. Anyone aggrieved by a decision rendered by this board may appeal that decision to a court of record. However, such an appeal must be made within 30 days of the board's decision. Any approved variance is effective at the end of the appeal period. Building permits for construction associated with an approved variance will not be issued until the appeal period is ended. Building permits must be obtained and construction begun within 180 days of the variance's effective date. Procedure for the meeting is that the case will be introduced and an overview be given by staff. The applicant will present their request and reasons the variance should be granted. Proponents will be given an opportunity to speak. Opponents will address the board, and then, if needed, staff will address the board again. The public hearing for case VAR 2025-010 is now open. The applicant is Mason Fox. The property is 4450 South Fox Street. All right.
Raise your right hand. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
State your name.
Eric Sampson, Planner 2 with Community Development.
Thank you.
All right.
Good evening. So the applicant's request tonight, this is for a property at 4450 South Fox Street. The property was recently purchased by the applicant in August, and they would like to obtain a short-term rental license to operate at this address. As per the code, there are a series of primary residency documents that are required at the time of the application submittal. Those are these here. These include a proof of residency and ownership affidavit, the first page of the most recently filed U.S. Tax returns, the 1040 form, which shows the primary address as the short-term rental address being applied for, and at least 2 other forms of identification or items for primary residence identification. And so there was, considering this type of situation, City Council included this Section D in 531.3A2D that documents required by subsections B and C above may be waived if the owner establishes compliance is legally impossible in an appeal to the Board of Adjustment and Appeals. So the applicant has provided all other necessary documentation for an STR application except for the 1040 tax return. And so Community Development recommends approval of this waiver with the caveat that when the time comes for the applicant to reapply for his short-term rental license, which are renewed annually, he will need to provide the most current 1040 tax return, which does show the 4450 South Fox as the primary address. If failure to do so would result in the denial of a STR application.
Okay, do we have any questions for staff? Forgot to note that I have the verification of publication for folks to look at. Any questions? All right, thank you.
Yeah.
The applicant may come forward to testify in this case.
If you can please raise your right hand, I'll swear you in. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes.
Please state your name and address.
Mason Fox, 4450 South Fox Street.
Thank you.
All right, so we've received the materials in the packet and heard from staff, but is there anything you would like to add or present tonight on the materials that you've submitted?
I think you might want to put your microphone on. I'm sorry. There should be like a star.
Sorry, is that better? I bought the property in August and we are just trying to get a short-term rental license so we can rent the property out. So it's not really possible for me to, because my taxes were already filed in April showing my previous residence. So there's not really a way for me to get that changed over.
Okay. Do we have any questions from the board for the applicant tonight?
I believe this was,
Okay, go ahead.
I believe it was stated, but to clarify, your intent was to live in the ADU and to rent out the primary structure. Is that correct?
Yeah, that's correct.
Thank you.
Ms. Ozels.
Can you share a little bit more about why a short-term rental is necessary versus, say, getting a short lease, having a tenant move in on a short lease basis instead? Why is the STR needed now?
We just believe that for the community to be able to bring new people to come here on a short-term basis, to see Inglewood, to see Colorado and Denver, just as it's good for the community, it's good for business, it's good for just getting people to see what our city is like.
Do we have any other questions? All right. Well, thank you.
Thank you.
Are there any persons present who wish to speak in favor of this request? All right. The secretary will administer the oath.
You raise your right hand. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes.
Please state your name and address.
Lori Fox, 4287 South Cherokee Street.
Thank you.
Okay. I guess I wanted to follow up a little bit on what Mason said, and when the question about why a short-term rental would be better than more like a short lease. I have a short-term rental in Littleton, and I just find that we take care of the property because we're in it so much, and I think it stays better than the standards of regular rentals. And he can make a bit more money than the lease, having it be a short-term rental. It is so expensive to live in Inglewood. How does a 30-year-old live without having other income like that? So that's why we helped him to secure the property for the plans to short-term rental it.
Does anyone have any questions? All right. Thank you.
Thanks.
All right. Seeing no other persons present to speak in favor or opposition, unless I'm missing anyone. Does staff have any additional comments, or does the board have any additional comments or questions for staff? All right. I will close the public hearing. I need a motion and a second for this request.
Move to close public comment.
All right, and we just need a motion on the request that the applicant is seeking an appeal to the primary residency documentation requirements pursuant to Inglewood Municipal Code 5313 A2D.
I move for the previously stated reason.
Do we have a second?
Second.
All right, let's have discussion.
Seems to me that this is a fairly straightforward request. We've approved similar in the past. Comes up for renewal in a year and they'll have the correct documentation. I don't know if there's anything more that a person could have done to meet the regulations.
I agree.
Yeah, I mean, housing is in part so expensive because there is no very little housing to actually rent or leases. And so I'm still a little bit confused as to why we would not want to encourage people to actually have tenants that can live in a place that is expensive to live in, that is partially expensive to live in, because we have things like STRs that are taking up housing. That being said, our job here is not to necessarily have that opinion. Our job is to say, have they met regulation or not? And they have. So it's pretty straightforward, regardless of whether I like it or not, is not relevant.
Okay.
Well, I have an objection to requiring a 1040 in the first place because that doesn't prove anything. You can file it anytime, and we have no way of knowing whether or not they've actually filed with that address. If they've met all the other residency requirements, that seems to me to be sufficient. But that's what the code is, and so I don't really have any objection. I just think the whole thing is ridiculous and a waste of time.
Well, not speculating on tax law, I think it's delightful with someone having the surname Fox that they choose to live on Fox Street.
Yes. It's excellent.
Seconded that for sure. Yeah.
I didn't understand what he
All right. Are you ready to?
Move to close the discussion and vote.
All right. Ms. Work, please take the vote.
Mr. Cole,
I vote for the reasons discussed to approve the appeal. It seems as if he has jumped through every hoop that he is capable of doing at this time, and with staff's recommendation that they just submit updated tax forms in the future, that seems more than reasonable, in my opinion.
Ms. Ozels,
Since we are supposed to share our thoughts on it while we do this, which I'm still getting used to, but yeah, just because I don't like it and think that it kind of displays exactly what some of the problems with STRs are, and allowing that, that is, again, not relevant. The code says that they have done what they need to do, and so I do move to approve the motion.
Mr. Friesen,
I vote yes to approve for the reasons.
Mr. Koenig,
I vote yes to approve requester Mason Fox has met all the criteria.
Ms. Dickerson,
Well, for the reasons Gina stated and everybody else, yes.
Chair Taylor,
I voted yes to approve this waiver for the reasons stated.
motion passes.
All right. Thank you. All right. So we can move on to the next item on our agenda. Back to that spot. We have our study session item around the waiver of primary residency for short-term rentals. So a slightly different topic, but in the same title.
There we go. Good evening, Chair and board members. My name is Brian Ice. I'm on the planning manager, and I'll be going through this with Deputy City Attorney McDermott to my left. So a little bit of background on our short-term rental process as a whole. The original ordinance was adopted in 2020 with waiver provisions that allowed for waivers of certain administrative regulations in special circumstances, such as the waiver of primary residency, especially in cases with medical adjacent uses. Short-term rental ordinances in Title V were adopted in 2023, primarily to include some platform accountability. Anybody was here for part of that, as well as some cleanup and the refinement of the waiver process. Current waiver process allows the board to waive or modify if the owner can establish conditions peculiar to property or owner not generally applicable. For example, medical or wellness district location or owned by a medical facility or adjacent to a hospital. Alternative effective means of assuring oversight and compliance without altering essential neighborhood character. Some examples of that are noise monitoring, affidavits from hospital or facility monitoring. Procedures followed Following approval, the waiver must state effective date, duration, and required conditions. And post-decision remedies, any interested party may request a rehearing within 30 days if new material evidence arises. Since the adoption of the waiver process in 2020, we've had 7 total requests. 6 have been granted, ranging from 6 months for their approval to 26 months. 1 was denied in 2020, and 1 property at 4477 South Pennsylvania has requested the renewal, requested the waiver twice. Of those 7 approved waivers, 5 of those locations 5 sites total were approved. 3 have since discontinued short-term rentals altogether. 1 is ongoing, and 1 was recently approved. What we've noted in a few of the most recent cases is we have a few issues with this section of our code, which is why we're here tonight to talk about it with you all. Number 1 is the lack of definition of predominant or predominantly. It's used in multiple provisions. We have some ambiguity issues, similar to what we had with the primary residence definition in the original ordinances, which were clarified in 2022 and 23. So the question we would ask, and do you want to stop at each question, or do you want to go through all of them and stop at the end? We'll do them all. Okay. So one of the questions we ask is, should a percentage threshold or any type of threshold be established for this definition of predominantly? Item 2 is the documentation of alternative effective means. Examples that have been given historically, such as affidavits from hospitals or medical facilities, affidavits confirming 24-hour monitoring, or guest records. Some of the issues that can rise up against are HIPAA violations. We do not want to violate HIPAA in asking for guest records. And so we would need some guidance on what documentation would be considered reasonable, consistent, and enforceable on our end. 3 is the burden that this puts on third parties. Requests for affidavits and documentation can place medical providers in a very difficult position. I think we saw that in our last case, where we had emails from one medical facility that seemed to contradict each other. Local hospitals do list hotels as accommodation options, but few, if any, STRs were promoted when we checked through their websites. That raises the question of appropriateness of conditioning STR approvals on hospital participation. The 4th item we ask is, does this process need to continue? We see very few of these, very few at all actually continue past that first year. So that's now the question we also have is, does the board feel like this waiver process is necessary for short-term rentals? We mapped out the majority of the waivers that have been approved. Not very many of them are actually located within close proximity to the hospitals themselves. They're kind of sporadically located across the city. So that's our fourth question that we have. So I'll put these questions up on the screen for you all to see, and ask the board if you all have any comments or questions for staff, or want to open it up to discussion amongst yourselves.
More questions? Yeah, go ahead.
So for question 4, would we be basically recommending that council just gets rid of this process? Is that what you mean for number 4? Or we can decide as a group what that means?
That could be. There are 4 districts, I believe, and I'm going to look at Eric. The MUB1, MUB2, M1, and M2 already have no primary residency requirement. It's only the R1, R2, and MUR3 districts that do have that requirement. Is that correct?
Does staff have an opinion on its continuation, the necessity thereof?
I don't necessarily have any. I wouldn't say that we don't have an opinion if all the other items are cleared up. That's kind of the crux. We need to do one or the other. But leaving it as is does not seem to be working very well.
I mean, administratively, so the city attorney's office doesn't quite handle these, but we do support when there are questions. And I mean, there's definitely ambiguity in this area. So if it were to continue, we would certainly suggest some code cleanup.
I mean, I think based on our experience, we've heard some reasons why like this is compelling and like we've granted this more often than not. So I think we've found some cases here. There are few in number, but I think we found some reasons to have this waiver process. But, yeah.
I have been made aware that there is no hospital in Inglewood that wants to participate in this in any way. They will not write any affidavits. They will not participate. So how are they going to prove that they're doing this? I would say that it should be discontinued. The only places that might be valid for not occupation are those one-bedroom houses. You couldn't do short-term rental and have an owner occupied in a one-bedroom house. That would be a unique situation. But then again, obviously, STRs aren't working very well for people.
This feels like it's more a matter for discussion and less a question for staff, though, correct?
But there, I would say that if we could get the hospitals to rent various houses for nurses or whatever, and they be responsible for it, that's long-term and that solves a problem. But the hospital keeps spreading out. All of the hospitals spread out. That's their goal. They have to have cranes on property all the time, and something always has to be done. They've wiped out a lot of single-family homes, and they're continuing to wipe them out. So there's no point in providing homes. It doesn't matter where the homes are. They're going to be close to a hospital.
Some of these items aren't material to a short-term rental discussion. I mean, you're asking about whether these could be long-term and in some other relationship. That would be material to this.
I'm talking about having a waiver for not having to occupy a house. There isn't really any reason to have a primary resident, the owner, occupy a house that he wants for families to be able to visit people. I think the whole thing should be wiped out.
Okay.
Forget it. If the hospital wants to provide more housing, then they can rent housing for.
I think something I would love if you could expand a little bit on is just to clarify for the board kind of the differences between because so the state has their own waivers, their own processes in terms of where STRs are allowed. You've talked about the different districts that are zoned for that. Could you help some of us understand a little bit better about the differences or how the city waiver interacts with that state law? Because I feel like there's some parts of this that are more just state law than they are anything that's actually coming through the city. If you could shine a little bit of light on that, I think that would be helpful.
Are you speaking about ADUs and the requirements for that, or?
So, because to my understanding, and please correct me if I'm wrong, is that the state created the law around you have to be in the primary residence. You have to have a primary residence, and then you can have an STR as long as you live there. That's not city law, correct? Or is that am I incorrect? Do we also have that in the city?
The city has laws that require primary residency for short-term rentals.
So it's both.
And the definition, I believe, is 185 days.
Yes, that's correct, within the calendar year.
Okay. Thank you. I'm just trying to understand the differences between what our rule is and what their rule is, and how this waiver then impacts between both of those things. So thank you. I'll find a better way to ask a question if it comes up, if I think of another one.
Would it be helpful to, so you'll find that local zoning is, it has quite a lot of purview. One of the nuances that Brian was pointing out, though, is that different zoning districts within Inglewood already allow the short-term rental by right. I believe those were just essentially more dense zones, correct?
So it's allowed by right in most all the residential, sorry, the primary residency requirement is not required for short-term rentals in the MUB1 and MUB2. So think up and down Broadway and portions of Hamden, on the north side of Hamden from Santa Fe to Broadway, and then the M1 and M2, which are the districts primarily south of the hospitals, to Hamden. Those are our general locations. Those districts have no primary residency requirement, where our code basically waives it and says you can have one even if you don't live there, it can still operate as a short-term rental. Our R2, our R1, R2, and MUR3 districts, which make up, the broad swath of Inglewood, those do require primary residency. But their short-term rentals are allowed as an accessory use in every district except the 2 industrial districts, I1 and I2.
And the main goal of that is preservation of community character, correct?
If you want me quoting things that occurred before I got here, I can't do that. I don't know exactly why the laws were written the way they were. The short-term rental laws came into effect prior to my tenure beginning.
Sorry.
But I think there may be a lot that has to do with where you would locate an apartment building, like thinking about renting, or where hotels are primarily located, which is likely in most of our commercial districts. Short-term rentals operate, similarly, and guest stays to hotels, things like
Gotcha.
Would you or your office have any kind of recommendations? Because I feel items 2 and 3 are very, very closely connected in terms of, because I super hear on, we don't want to violate HIPAA, we don't want to. So would you, for either questions 2 or 3, would your office have any type of guidance into what would be documentation that you would look at for something like that? And it's okay if the answer is no. I'm just curious if you've given any thought to kind of what would you want to see from the phrase alternative documentation?
Yeah, we don't have any right off the top of our heads. No, we're coming to this board first before we start diving in to get some kind of direction on whether y'all want us to look at improving these first 3 questions or looking solely at the 4th question forward that way. So we're more than happy to start looking at other municipalities and what they might require. I don't know if other municipalities have a waiver process like that. That would be the second thing that we would do if we were going to go to council, to start looking at revisions or start looking at how many other cities have similar processes to this. What do they do? What do they require?
Do you have a ballpark of how many hours it takes to prepare and go through one of these cases, like your department, every time it comes up?
Eric does most of them, so I'm going to defer to him.
So to clarify, you mean just process?
I'm just
Now this.
this situation. I'm trying to see if we smooth this process out, how much time would it save your planning department with this?
Really hard to.
A ballpark sufficient. I don't know if it's 2 hours or 20 hours. I just don't know.
I would say overall, finish from initial application review to staff reports. And then it's like conversations with the applicant.
In the back is Dr.
Can we get you on the mic?
Should I ask the question again? Or are we good? I just already asked the question, but yeah, basically, how much time does this take your office per case? Just get a ballpark of how much time we potentially could be saving if we went with option 4.
So, yeah, for this is probably from initial staff application review to going through the whole Board of Adjustment process. I would say probably at minimum 20 hours of staff time. And that's between going back and forth with the applicant, if there's additional items we need, if there's other things that they need to provide for the case. Just really a large part of that also hinges on the responsiveness of the applicant. Oftentimes when we request documents, not necessarily for for Board of Adjustment cases, but just for general short-term rental applications. We're like, hey, you need to get us X, Y, and Z documents, and it could be a month turnaround time before we get those back. So it really depends. It's really a case-by-case basis.
Great, thank you.
Yes, ma'am.
Back to question number 3. How can you rely on something that we have been told is never going to happen ever again?
I mean, we've seen it before. It just was the last case where someone mentioned that.
No, they have said since then that they will not be a party to our process.
Yeah, that's the latest info, but yeah.
And we couldn't really rely on it in the last case either.
Yeah, I think that was the first instance where we had received another email saying something contrary to a prior email that we had received from an applicant. So that's definitely why we're asking the question. You know, does this process still need to depend on somebody that may not be responsive to somebody reaching out asking if they would be? So that makes it, you know, even more difficult, even if we can answer questions 1 and 2.
Well, it would eliminate all the other things.
Correct.
It doesn't matter what predominant is if we're not going to have anything to rely on.
Well, I mean, then the question is, if we don't rely on that, is there something else that we look at as a location-based, only properties within this certain area can do it? Or there's always different ways to do it. It's just saying, if we don't need to do it this way, is there another way that we could do it?
But if the hospital isn't going to cooperate, how are you going to get anything resembling a predominant use?
I'm trying to understand on number 4, if we discontinued the process, what the ramifications of that are. I mean, it seems like there's a lot of effort that goes into doing this that doesn't benefit much of anything, in my opinion. It seems like it would be easiest just to eliminate it, but maybe I'm missing something here. If we don't, then we have to come back to items 1, 2, and 3. So that's really my question. Then we can talk about 1, 2, and 3.
I think that's the question we have for you all.
Yeah.
Do you want to focus on number 4 and just go that direction, or do you want to open it up to questions 1, 2, and 3 and start to try to refine that waiver process? Since we know what's not working right now, this is the opportunity to start to refine it. But should the board choose to go forward with a positive vote on number 4, meaning discontinue the waiver process, then that's where we would go to council.
Yeah, I think
with that.
I think with my concern, if we just were only to sound off on number 4, is that if council wants to continue having these waivers, then we wouldn't have really sounded off on some of the true problems of how do we document it. So I think we could still say, we could still have a consensus or here that maybe the waiver shouldn't be continued for a variety of reasons, but maybe we should still try and send some signals about those first 3 in case they want to continue doing it.
One thing I do want to address about Member Frieson's question. So if the waiver process were to be discontinued, so first off, it kind of seems like the waiver process was very much intended to address individuals that wanted to stay in the medical districts. Currently, the zoning requirements within the medical districts, there isn't a primary residency requirement, so it wouldn't impact those homes within that area. So it would really only impact the R1s. Eric listed them all off on that at all the zoning areas within our city. But the overall intent of the waiver historically had been to address patients within the city, nurses, folks that are working within the hospitals, and they would continue to be able to utilize short-term rentals without the primary residency requirement.
Vicki, would the 2 properties that have recently been approved, would they be allowed to continue to operate until their waiver expires?
Because they're not within the medical districts, so that's something we would need to look at. I believe the recommendation that our office would have would be that since they would have obtained the waiver while the requirement was still in existence, it would essentially just operate during the time period that they have, and then it wouldn't be eligible for renewal should there be a code change.
The one that's coming up for renewal, is that the one bedroom?
I don't know that we have one.
There
coming
was
up.
a one bedroom. She advertised it as a healing house, and it just had one bedroom. It was a really tiny house. And so she got a waiver, and she's the one that brought up, she made a spreadsheet and proved that she had rented to people who had either relatives at a hospital or were visiting. And that brought up the whole idea, well, what is predominant? Because nobody else came back for a renewal or could prove that they had more than 50%. And she had slightly more than 50%.
And that property has been discontinued.
But she's the only one that produced this. Nobody else ever came back with a renewal.
There was one property that was renewed a few years ago, I believe, but I know they've been discontinued since then too, if I remember. That was the same one? Okay, that was the only one. And now they've discontinued their short-term rental, so.
It was the one bedroom that was discontinued?
I'm
She's
gonna-
the only one that, I mean, I wasn't on the board when, in 1920 that I know of. Was I? I don't think so.
I don't think any of us were on the board in 1920, but hopefully 2020.
I mean, 2020.
Yeah, I think she
I
was.
wasn't even
she
born
was-
in
She was the
1920.
first one who went through the waiver process, and then she came back for a 1-year renewal. And then during that second year, she decided that she not. But yeah, she was.
Well,
the
I
one who
remember the
provided
one
the
bedroom.
documentation.
That was the first one I heard, I think. And she's the one that clued
Yeah.
us in. And we started requiring the spreadsheet.
Well, I think the predominant question for me has always been more than a number. It's been, what's the denominator? I do not know what the denominator is to get to that percentage, because is it nights that it's vacant? Do those count against the uses, or is it just of the stays that would we count vacancy against? So that has been another question I have had, and I think in doing that documentation, it just makes it more
I
complicated.
would agree
too.
with you on that. But as far as the rentals were concerned, she
She was the only one that had renewed.
was the only, well, she was the first one that I saw. And it was the only one I've seen
And that's
because
the
she
only-
could prove that
That's
she
the
had
only
the
one we've had.
spreadsheet. So everybody else was first timer.
Yeah, we haven't had, that was the only property. We've only had one property that came back for a second waiver. But again, everybody else has discontinued.
And I believe it was her. I think when I saw the spreadsheet, that was her getting a renewal.
I don't know about the one bedroom part. I just know, I do remember there was one property that came.
But that was a one bedroom.
I'm interested in this idea about location as maybe a way of showing some relationship to the hospitals or the medical district. There are properties that are nearby that are not in the medical district, and that's something that would be fairly easy to document if it was a certain distance, or then we'd just be looking at a map. We wouldn't have to get into number of stays, and if that's truly the intent that council had or planning commission had when they were discussing this, to leave this alternate opportunity, I think location could be a good thing to use.
Are we open to discuss among ourselves? Or are we still in the questions? I'm ready to discuss, but
We're kind of bouncing back and forth,
okay.
but
I just want to start discussing if we're going to get
I
this
think
off track.
questions may come up as we're discussing
Okay.
too.
And that's okay.
Yeah.
I just wanted to say that I think that doing like a walk shed or something similar would be the most straightforward way. And then to kind of talk about one, I feel like just to put something out there for discussion, in my mind, predominant wants to be plurality of rented nights. So if you're vacant 95% of the time, it doesn't matter. For the 5% of the time, if the plurality of the duration of stays was for this reason, it would suffice.
So, for example, if 100 nights were rented out, you'd want 51 of those nights to be.
No, plurality. So like if I had 38 of those was for hospital stays, but then each other chunk was for a different category. Like it might just because of the number of like possible uses end up being that majority is more common, but I think that plurality would suffice in my mind for predominant.
So correct me, but predominant is basically for anybody that's reapplying, right? I mean, when you first come in, you're not going to know what you have.
Well, that's been the struggle from
Yeah.
how it's
Yeah.
written right now is we don't get it. People are coming in for the first time. They don't necessarily have a predominant.
And they have no way of knowing. I mean,
No.
there's no reasonable way for them to know.
Well, and the other thing I think we've discovered is that it's hard for us to know even after a year because people don't share their reasons.
Yeah, I mean, to be clear, I think it's silly in general, but to your earlier point of like we should discuss what each one of these just for council's consideration, that's
Yeah.
my rough draft.
If they wanted to keep predominant for a renewal of a waiver, yeah, I agree.
I think whatever process we decide, I'd like to ask council to make it by right instead of coming to us for some of these. I think it's a lot of time for staff, it's a lot of time for us for things that I think council probably didn't know the consequence when they wrote it in 2023. So if we're going to talk opinions, I think my personal opinion is more for question 4, should it be discontinued or not? I think we should just recommend to council either approve them by right or discontinue.
Yeah.
Just that's a binary. And yeah, so that's I'm going to say that opinion there, and then I'm going to see if people agree or disagree with me, see if we can build consensus there or not, and then we can move on to if they still want this process, then we can talk about that.
Yeah.
So, any thoughts on my opinion there for how we deal with question 4?
I would completely agree with you, Sam. I personally, I don't see I don't see the rationale between the time spent on this, especially without that lack of clarification. There is still appeals processes that people can go through. There's still so I personally don't see, I think it's very silly that we have these level of unclear deadlines. And so or not deadlines, but expectations that we cannot even define ourselves. And so I would be with you completely, Sam. I would recommend that we simply get rid of the waiver process for this. But yeah, if they do insist upon keeping it, like these are going to be some potentially longer conversations,
I would concur with that as well.
Agreed.
Yeah, I think there could be a better way to specify the location and not need the waiver process because verifying the location shouldn't take a waiver. I also think there's a lot of different ways that folks can have an STR and still have it as their primary residence. We have more opportunities for, I think, folks to build ADUs in more places. There are districts where this is allowed by right. I mean, it's not like we're saying no anywhere in the city.
If we did it the way we do other exceptions and waivers and different things, is there a unique situation in this particular property that would allow us to waive the primary residency requirement? A one-bedroom? That would be a unique situation where there would be no way for a person to occupy the space and still be able to rent it out.
So remember, short-term rental regulations lie in Title V, in which you only have authority when it's given to you. Which means if you remove this waiver process for primary residency requirements, there is no coming to this board. They are allowed where they're allowed, and that's it. Now, there would still be the primary residency documentation waiver, like we saw tonight, that would still exist. But for areas where it's not allowed, it's just, you're not allowed to do. So that's what would happen if we remove the waiver process.
I think that kind of what we're talking about is essentially trying to establish perhaps like a distance metric from the desired, and then it doesn't need to come to the board. Would that be feasible?
Certainly. We can do a lot of things. But if council chooses to go that direction instead of just eliminating the process altogether, but says, okay, now everything within 1/8 of a mile of a boundary of a property, we would just have to come back and clearly define what that distance is, and make sure we clearly define, are we talking entrance to entrance? Are we talking property line to property line? I know Andy probably has, Chair Taylor probably knows kind of the ins and outs of zoning code, so we can do this.
Just to talk a little bit on too, I'm not really sure that I honestly cannot imagine what would be effective documentation at that point. It feels nothing that would be verifiable, honestly.
Right.
Yeah.
I mean, I think essentially that it would be some sort of affidavit by the property owner about what kind of renters or who it would be. You wouldn't be getting it, obviously, any medical information, but it would be just their affidavit about how the property was being rented and used. So it's primarily just relying on that person's word.
Sorry, does anyone smell smoke?
I do.
Yeah, we're just
Yes.
Yeah. Checking it out.
Okay.
Yeah, I smelled it right away.
more like birthday candles.
Yeah, at first
Love
it smelled
it.
like a
Burger King's across the street. It's possible that there's something cooking there, and perhaps the doors are open. We do
Okay.
just waft in from time to time.
Sorry, I didn't mean to take
No,
away
no,
from
it's
you.
totally
It does-
fine.
Like a Whopper.
Burger
It's a
King.
good point.
when everybody
It's okay.
starts to smell it, it's something you got to check for.
Just to provide a personal example, my wife was a travel nurse before when we first moved to Colorado, and we did stay in a shortest term rental for her to have housing near a hospital. So like there are cases that do exist. Yeah, I just want to provide that personal anecdote just for the group.
Yeah, I don't question the need so much as like it just seems like this could be handled more efficiently by a different metric. And because it's been so infrequently sought after in the last, 6 years, it feels like that would just be the more efficient way, and we're not necessarily denying anyone anything based on that.
Yeah, the criteria are so, it feels so different from the other cases that we hear in Title 16 that I don't quite know how to state that. It just feels like we're looking for evidence that's very like binary on some of these things of like predominant and, documentation of affidavits and these other things. And we don't really have there's not a lot of judgment that we're using after we see all these things. It's just sort of, are the pieces in place for us to grant a waiver? I think that can be done more straightforward and more predictably for folks, so they don't have to keep coming back to.
Do you need consensus from us, or do you just need all of our ideas and you'll bring those to City Council?
I think both. It sounds like there's a pretty big consensus behind number 4, but maybe looking at a location-based, proximity-based to our 2 major hospitals or somewhere to propose to council to say maybe in lieu of this, maybe think about this, and then making it more of a by right decision rather than having to go to the Board of Adjustment.
I think I agree with that, and be
Yeah.
happy with that going before council.
Yeah, and I do too. I think the problem is that we don't have the tools to really judge. Predominance is the closest thing we have, and then we'd have to define that. But other documentation we don't have, and we're not getting the third-party stuff from the hospitals. So really, we don't have tools to make judgments. So they're asking something that's not really possible.
I think we need to eliminate number 3 because we can't rely on something that doesn't exist.
Sure, and if we choose to go the route of 4, it eliminates all 3 and says the process won't exist anymore. So
Well, in any case, 3's gone right now. Unless you change the mind of the hospitals. And they're not going to change anytime soon. They are angry.
Would it be worth the discussion between like planner and council, essentially that maybe we want to be more than just like hospital medical facility? Like, is it just the 2 hospitals? Is there, I don't even know, is there like a hospice facility in Inglewood? Is there any other uses that we want to accommodate with a similar carve out?
we can certainly ask that question. I'm not personally aware of other facilities aside from Kaiser up on Broadway, their offices. But we can certainly do that research.
I do know in one of the Inglewood newsletters it said a 60-some unit hotel might be going in the medical district. So, am I correct on that? It got permits at least. So
They've had some building permits approved, but they haven't. Last I checked, I don't think that they had been issued yet.
okay, so may or may not be relevant.
Yeah, I think that speaks to why this carve out was made in the first place, is that there's just no place for people to stay when they're here helping take care of someone that's in one of the hospitals.
Yeah, and I think it also sounds like we've got good consensus on the goal of the carve out is admirable. It's the functionality of the carve out that is just not there. I get why they wanted to do it, but I personally don't see how you can accomplish 1 through 3. I genuinely don't see what recommendations we could even give you to say, how you could fix all of those problems. But it's admirable, and I understand the reasoning why. But I just don't think that it can be done via this particular waiver process.
Is there anything else you need from us to kind of like close out or anything? Because I'm sure we can talk all day, so. But I just want to make sure we're answering your questions that you need.
I think you've answered my questions, Vicki, or you?
Yes, this has been very helpful. So I think we have something that we can work with.
Yeah, we really haven't discussed number 2 on alternative effective means for that they'd be off-site but controlling the property. But I feel like that's the one that we've gotten the best explanations on in the past, of like people tell us where they do live and how close they are, contacts that they have with the neighbors, that kind of stuff. So I think we've discussed all of these.
Yeah, I'd agree. Should we move to closed discussion, or?
I don't know what we need to do in a study session. We don't have very many study sessions.
See, I was also going to say, Mr. Chair, I know we're not, I know this is not, if we even do public comment during this, but I did want to make a note that we do have someone who seems like they want to make a comment. I don't know if they can or not. I just wanted to make sure that you
I
can
think
see.
we're good.
Well, it wouldn't affect them anyway because they're not seeking a waiver of primary residence. They're going to live there, or at least one person is going to live there.
Oh, for sure. I'm not saying to comment on this specifically. There was a human being who seemed to want to say something, and I was like, I don't know what the rule is, and I didn't know if you could
Not
see
really.
him. That's all.
No, I think we've had a good discussion. I think there'd be other chances for public comment on this issue. We're not the final deciders.
Next month they could comment if they wanted to.
But no, I think we're good. Thank you, though.
I would encourage any members of the public who do have insights or opinions on that to share that with council.
Yeah. I will just take my privilege to note that when I first moved to Inglewood, I did live in a short-term rental. It might be why I located here, but there was a primary, there was an owner who lived on site, so it would have been allowed under these rules.
I mean, it seems like if this is just a study session and we've kind of given our opinions. So
Yeah.
I don't know if
We're
there's more
good.
we can add.
I move to stop studying.
Yeah, I think we've studied.
Second.
Thank you. Thank you for bringing this back to us since we did request this, so we appreciate it.
Thank you for your input. Very insightful.
All right. I think that's our last main item. We have still remaining on the agenda, just some normal headers for staff's choice, attorney's choice, board members' choice. Does anyone have anything else? Do we have any cases next month? We do.
Sounds like we do have something. coming up.
Excellent. Keep it on the calendar. All right.
See you in a month.
Stand adjourned.
Move to adjourn. Adjourn.
Thank you.